Hi, this is Josh Blackman. I am the president of the Harlan Institute, and it's my honor to welcome you to the 2020 Supreme Court, the 2020 Virtual Supreme Court competition from the Harlan Institute and Ashbrook. Today, we're arguing the case of Torres versus Madrid, and we have two excellent teams. For the petitioners, we have Wynne Conger and Grace Halak. And for the respondents, we have Pranav Saravanan and Siddhant Urunkar. All right, we'll begin with the petitioners. If respondents can please turn off your camera. Petitioners, you have 10 minutes. Begin whenever you're ready.
Mr. Chief Justice, and may it please the court, my name is Grace Halak.
Conger.
And together we will represent the petitioner in this case. The question presented today is whether an unsuccessful attempt to detain a suspect by use of physical force is a Fourth Amendment seizure, or if physical force must be successful to constitute a seizure. Would you like a statement of the facts?
Yes, please.
On July 15th, 2014, officers Madrid and Williamson arrived at an Albuquerque apartment complex to execute an arrest warrant unrelated to petitioner Roxanne Torres. They approached Ms. Torres near her car in plainclothes and failed to announce their intent or identity. She entered her car, and when they attempted to open the car door, she mistook them for carjackers and shifted into drive. In response, the officers opened fire and continued to fire as she drove away, shooting a total of 13 shots, 2 of which made contact with her back. Paralyzed in her left arm by the bullets, Ms. Torres then drove herself to a hospital where she was later apprehended and charged the officers with the violation of her Fourth Amendment rights through their use of excessive force in her unreasonable seizure, arguing that the officers had in fact seized her the second that she was shot. My co-counsel would like to give a summary of the argument.
Please.
An unsuccessful attempt to detain a subject with physical force is absolutely a seizure within the meaning of the Fourth Amendment, and therefore Ms. Torres was seized when officers Madrid and Williamson shot her, even though she continued to drive away. This interpretation comes directly from common law arrest precedent, which this court has long used to judge Fourth Amendment seizures, most notably in California v. Hodari D., which held that to constitute an arrest, the quintessential seizure of a person under our Fourth Amendment jurisprudence, the mere grasping or application of physical force with lawful authority, whether or not it succeeded in subduing the arrestee, was sufficient.
Oh, if I could just jump in there, let's talk about Hodari D for a minute. I think that's a very important case.
Of course.
Counsel, what exactly was the holding of Justice Scalia's opinion there? What exactly did Justice Scalia decide in that case?
I can answer that. So the facts of Hodari D involved a suspect fleeing police and then discarding a rock of drugs after the police officer had enacted a show of authority by chasing after him and yelling stop and such, but before the officer physically tackled him. So Justice Scalia, the question that Hodari D was concerned with was the success of a seizure and how that affected whether it constituted as a Fourth Amendment seizure or not. And Justice Scalia held that a seizure, the definition of a seizure is twofold. One, a seizure can be affected through physical force, such as the tackling, and there, any physical force, regardless of success, constitutes as a seizure. And then the other way a seizure can be affected is through a show of authority, such as the seizure conducted in Hodari D before the drugs.
I think that's an accurate description of the facts from Hodari, but my question is, what was the holding? In other words, Hodari D didn't involve a physical touching of the person, successful or unsuccessful. Is your rendition of that case the holding, or is it just, maybe Justice Scalia was just thinking about some other issues?
Although the element of the Hodari D argument surrounding physical force seizures, no, it was not necessary to the facts of the case because, as you said, there was no physical force seizure. I do think it was quite essential to the argument and essential to how Justice Scalia reached the holding and the definition of a Fourth Amendment seizure.
Okay, thank you, Counselor. You can proceed. Or if another justice, I'm sorry, wants to jump in, you're welcome.
I'll jump in with a question. How can, just as a matter of plain English, how can the word seizure cover in a situation or an event in which the police never gain any control over the subject?
I would again point to Hodari D in that respect, and the example that Justice Scalia used, which is the phrase, I believe, she seized the purse snatcher, but he escaped her grasp. And in that sense, the word seizure in colloquial language does not require success. But I also think it is important to note that that when analyzing constitutional law and writing, it is not, I would say, accurate to rely solely on colloquial, like modern English language, but to refer back to the original meaning of the term, like in the Constitution as the framers intended it. And I think that is, in of itself, a much broader definition than how we might use seizure or seized today.
Well, then if I could just ask a follow-up to Justice Tableson's question, this is a question for Wynne. What if I were to just, tap someone on the shoulder? Is that enough for a seizure? I just, tap, a police officer goes up on someone and just taps them on the shoulder. Is that a seizure?
If it's in terms of simply tapping someone on the shoulder, okay. A seizure falls under, if there is an application of physical force, then by definition, it is a seizure in itself if there is the intent of lawful authority to arrest a subject. So in the case that an officer went up to a subject to tap them on the shoulder with the intent of arrest, then under that definition, the subject will.
And then how do we determine what the officer's intent is? What would we look to? I mean, we're just all we have are the facts where an officer goes up and taps the person on his shoulder. That's all we have.
If the officer
didn't say anything, just tapped him on the shoulder, and the person started running away. Sort of the facts like we have here, but instead of shooting them, they just tapped him on the shoulder.
If they just tapped them on the shoulder, in that case, I feel like it falls to the officer's intent of arrest. If an officer simply goes up to a subject and taps them on a shoulder and the subject runs away, if the officer did not do so with the intent of lawful authority to arrest, then unless there was that intent and involved, I would not qualify that as seizure. However, if an officer went up under lawful authority to arrest a subject with that intent, and then we may qualify that as a seizure via the application of physical force on the shoulder, however light.
Okay. And Justice Vashkup, any questions? I want to make sure we get a question from the full bench.
I do. I'd like to know how you respond to the respondent's argument about even if this was a seizure, it was not reasonable, because that's the other element of the Fourth Amendment, is that it has to be a reasonable search and seizure. So how do you respond to the fact that this was reasonable or unreasonable?
So no, we would argue that this was not reasonable. Ms. Torres was in fact an unarmed, innocent bystander with no relation to the arrest that the officers were planning to carry out. And they did not announce themselves as police officers and were wearing plainclothes. So Ms. Torres had no reason to believe when the officers approached the car that she should stop, or, that they were police officers and she should not drive away. And furthermore, officers Madrid and Williamson stated that they shot at the car to stop its movement because they wanted to prevent it from running into Officer Madrid, who was standing near the front corner of the car. So that was the perceived threat that they perceived at the time. But arguably, the number of shots, which was 13, and the fact that many of them were fired after the car continued to move past Officers Madrid and Williamson, where it posed no threat to running over Officer Madrid, is not consistent with that argument and their perceived threat. And additionally, the bullets were not consciously aimed at stopping the car, which was the threat they were trying to stop, but were aimed erratically, as is evident by the fact that 2 of the bullets hit Ms. Torres in the back. And so shooting an unarmed civilian, a bystander, to stop their vehicle twice in the back is not excessive, but also completely unnecessary and unreasonable.
But you would agree, I think, that a person who's driving a car is a pretty substantial object. Someone who's wielding that essentially as a weapon towards an officer, how does that factor into that analysis?
I think yes, but the location of the car, it was driving away from the officers. I don't think shooting, or I would argue that shooting at it multiple times, even after it is past the officers and it was quite a reasonable distance away from the officers, it's no longer a threat at that point. And she was unarmed, so that was hitting the officers with her car was the only real threat she could have posed.
Okay, you have 10 seconds left. You have one more sentence, or you can wrap up. Okay, thank you. All right, very good. If the petitioners please turn off their cameras in response from their cameras on, and response will have 15 minutes whenever you're ready to get started.
Mr. Chief Justice, fellow justices, may it please the court. I, Siddhant, and my partner, Pranav, represent the respondent's Officer Madrid. The issue confronting the court today is whether an unsuccessful attempt to detain a suspect by use of physical force is a seizure within the means of the Fourth Amendment, or must physical force be necessary and successful to properly constitute a seizure. And that was the facts of this case. On July 15, 2014, Officer Madrid and Williamson saw Roxanne Torres tripping out from methamphetamine and running to a nearby Toyota Cruiser. As respondents approached the vehicle, Petitioner drew out of the parking space, threatening the lives of the officers and nearby pedestrians as well. And so, both officers fired their guns and struck the Petitioner, who kept driving without pause until she drove to a hospital in Grants, New Mexico.
And now, today, the respondents have two principal arguments. First is the standard established in Broward v. County of Inyo, which argues that for a seizure to occur, there must be an acquisition of control through means intentionally applied. This Broward standard is foolproof of every single physical force seizure case after Broward followed it and required the two checks of Broward that matters. And it is crucial to recognize that any comments about physical force that Petitioner argues from Hodari was simply non-binding dicta and overall inapplicable to future cases. In fact, that is why cases concerning physical force seizures, such as Brooks v. Genzel, where the defendant shot the plaintiff, and in fact, after shooting the plaintiff was still able to run away without pause. The court disregarded common law and Hodari instead, and Hodari as well, and fell back on the Broward standard to conclude that there wasn't a seizure. But second, even if there was a seizure, it would be within the bounds of the Constitution because the seizure was reasonable. Torres was clearly under the influence of methamphetamine and was making.
If I could just jump in. So your friends on their side were talking about Hodari, which I think is a very important case. You say that Justice Scalia's discussion of the physical seizure was dicta. Why was that dicta not part of the holding?
Yes, Your Honor. As respondents, the respondents argue that the ruling of Hodari should have little effect on the present case of Torres v. Madrid. And the reasoning is actually simple. In Hodari D, the issue was simply centered around whether or not a seizure occurred at the time the accused dropped the drugs. There was actually nothing about physical force in the actual case. It was simply an isolated comment that we used to serve a comparison to whether or not Hodari was seized by show of authority. It was complete non-binding dicta and was not pertaining to the details of the case at all. Which means at the end of the day, it is very clear that you should side with the respondents because the cases that the respondents provide as precedents, such as Broward v. County of Inyo, Brooks v. Genzel, U.S. v. Hernandez, all look at unsuccessful and successful use of force of seizures to find that a seizure can only occur with an acquisition of control.
Counselor, maybe you're right that Justice Scalia's opinion was dicta, but maybe we can just find Justice Scalia persuasive. He was a pretty smart guy, right? He had a lot of really good opinions in his career. Why don't we just find Justice Scalia was correct and call it a day there?
The reason we cannot is because the ruling of California v. Hodari was built upon the common law. And as the respondents argue that the common law, which Justice Scalia based the opinion on, has too many limitations. In fact, the common law that Hodari used was derived at the time of the founding, where there was no real police force and the weapons were in fact rudimentary. Obviously, society has progressed very far which is why Tennessee v. Garner indicates that the Fourth Amendment should not be construed in light of the common law due to the fact that the rule has been distorted beyond recognition, and there has been a great variation in legal and technological context, which is why cases concerning physical force seizure after Hodari and after Brower, such as Brooks v. Genzel, they disregarded common law. They took into account Hodari's ruling, but still chose to fall back on the Brower standard to conclude that a seizure can only occur with an acquisition of control.
Counsel, how do you draw the line in your test? So imagine, for example, that the police shot someone and she managed to run 50 feet and then she collapsed. Is that a seizure? And if so, at what point did it become a seizure? And how do you differentiate between that scenario and a scenario where she went half a mile and then died?
Of course, Your Honor. Simply put, the respondents rely on the Brower standard. And we would argue that the Brower standard set two cases and two, for instance, checks for there to be a seizure. It posited two things. One, there must be intentional acquisition of physical control, i.e. some sort of termination of movement, through two, means intentionally applied, right? Any seizure, insofar as the officers were intentionally attempting to kind of seize the subject and end up terminating the subject's movement, we would argue that that would be constitutionally a seizure under the premises of the Fourth Amendment. And furthermore, we would say that this Brower standard has actually statistically and historically been very solid, as every single physical force case following Brower actually relied on this Brower standard and neglected Hodari D and the petitioner's arguments of common law, such as Brooks v. Genzel.
Okay, so in the example I gave where they shoot someone and then she's later stopped, but not right away, when did the seizure occur?
Of course, Your Honor. So we would argue that when the subject lost ability to move, and thus was and under that condition they would be acquired by the police. So for instance, right, say the petitioner was shot and sort of moved away. We would argue that the moment the petitioner stopped moving, right, and thus lost all sort of control over herself and her liberties, full control, then at that point it would be a seizure because there would be means intentionally applied and a full sort of forsake ability of actual liberties and movement.
So the shooting itself would not be a seizure in that, but it would be a seizure when they sort of ultimately apprehend her and put the handcuffs on?
Correct.
Okay, so then would the shooting victim in that situation have any means of challenging the shooting as being unreasonable under the Constitution if the shooting itself was not a seizure, even though she was later arrested?
Yes, Your Honor. Under the premises of the Fourth Amendment posits two things. First of all, that it asks the question whether there was a seizure or not. And if there is no seizure, then the argument of reasonability would not be held, because insofar as there was no seizure, there would be no discussion of whether it would be reasonable or not, because it didn't happen in the first place.
But wouldn't you agree that your standard that you're advocating the court to adopt would encourage suspects to flee, would encourage them to try to get away from the police, because there's no reason for them to stop. There's no reason for them to submit to authority. And ultimately, it would be better for them to do so because they're not protected by the Fourth Amendment anyway, until the moment they can essentially goad an officer into laying hands upon them.
Yes, Your Honor. Regarding the inclination of the suspect to kind of get away, right? I would say that that inclination would be existent in either scenario, right? Because insofar as you're a suspect, right? I think that you would still be inclined to kind of run away from the police if you had the ability to kind of get away. And insofar as that's true, the suspect, it doesn't matter if like there needs to be an acquisition of control or not, because if the suspect would still has an ability to kind of move away from the situation and run away, then they would take that chance regardless of whether there needs to be an acquisition of control or not.
Let me, counsel, if I can give you a hypothetical. You know, the plaintiff in this case was Superwoman, right? She was shot twice. She managed to get up, drive, 75 miles to another city. Wonder Woman right here, right? She's Superwoman. But not everyone's so strong. I suspect if you shot me, I go down with one shot and I wouldn't get back up. Is the test you're proposing premised on how strong a person is, how many bullets they can resist? I mean, what if you have a little meek person like me who, the officer just gives him a little shove and I fall over? I could sue for a Fourth Amendment violation because my liberty was deprived immediately. versus you have some superwoman, right? Like the plaintiff in this case, who goes on and drives 70 miles. How do you give us a test that's premised on a person's ability to withstand bullet shot? That strikes me as a very difficult test to apply.
Your Honor, the reason the test, the Brouwer standard that the respondents put forward is applicable in all these scenarios is because no matter what, the Brouwer standard argues that after means are intentionally applied, it all comes down to whether the suspect's movement is terminated and whether the officers have complete control over the person's movement. So let's say, yes, they were only able to take one shot and then they collapsed. That would simply mean that the police officers would then have acquisition of control over the suspect at that moment, and the seizure would be completed then. In the present case of Torres v. Madrid, the two shots clearly did not hinder her movement as she was able to drive 75 miles from Albuquerque to Grants, which just indicates
so
that—
Counsel, let me try to I want to figure out the limits of your rule, because I think you're giving me a very good rule. How do we actually define, when a person stopped? What if, they're stumbling, they're bleeding, they're sort of just dragging themselves with their hand, they take their hand in the dirt and they keep pulling themselves in, right? At what point is the person actually stopped, right? When they're just paralyzed, when they're unable to walk, whether they can drag with their arms, whether they can, sort of roll over, I'm trying to, you can imagine when a person's shot, they sort of react in very unpredictable ways. Their mobility might be changed. What's the test you would use when a person actually completely loses their mobility? Is it just completely paralyzed? I mean, passes out? What's your test here?
Your Honor, the respondents argue that there needs to be a complete termination of movement up until the point that the suspect has lost control of her liberties and cannot move away from the police officers. The suspect is not seized.
So if a person is writhing in pain, kind of like, rolling around in pain, that they haven't been seized yet?
If they're still able to move away from the police officer, then that indicates that they still retain their liberties and they still retain some sort of freedom of their movement, some extent to the freedom of their movement. The only scenario where a seizure does not occur is when there's a complete termination of their movement and there is no way they've given up their liberties.
So that would mean basically paralyzed but not dead. Because if they're dead, I think Tennessee v. Gardner says they're seized. So it's basically paralyzed but not dead. That's the test we have.
No, the test is, as the respondents argue, at any scenario in which the suspect essentially gives up their acquisition of their freedom of movement. So in the scenario, if a bullet did pierce her leg and she fell down, she would not need to be completely paralyzed. If she fell down and was not able to move at all, and the police officers were able to acquire her movement, that scenario itself would constitute a seizure.
Okay, thank you, Counselor.
I take your point that the common law might not be the best fit for modern policing practices here. But generally, we think of the common law as establishing a floor of rights that we don't want to dip below. And we might expand the Fourth Amendment to provide more rights, but we wouldn't want to interpret the Fourth Amendment in a way that protects fewer rights than it did at the time of the founding. And it does seem like at common law, an arrest could be affected by mere physical touch, even without obtaining control over a subject. So wouldn't your proposed rule have the effect of reducing Fourth Amendment protections below the common law floor?
Your Honor, the respondents have a very simple claim to this, and it's simply that the common law is not the end-all be-all. It is a simple guideline, and it should be taken with a grain of salt. In many scenarios, it is too archaic and it has too many limitations to adequately uphold the Fourth Amendment and to actually give the liberties of the people. In this scenario, it is important to look towards the Brouwer standard, because the Brouwer standard adequately looks at current society, current technological and legal context to come to the conclusion that the only time a seizure does occur is when, through means intentionally applied, there is an acquisition of control.
Okay, Counselor, if I could ask maybe one more question. Are there any cases from common law England that you think help support your forget America for a minute, but let's just say we want to look at the common law. What's the strongest case from England that you think supports your position?
Actually, Your Honor, in this regard, the respondents would argue that common law cases as a whole should be inapplicable to the present case of Torres v. Madrid simply because of how archaic it is and the limitations of its guidelines.
We're all originalists now, aren't we? Aren't we all originalists now? Don't we look to the common law? So there are no cases that help you?
We would argue that it is more important as respondents to look at contemporary cases such as Broward County of Inyo to provide a greater scope and a greater variation of the legal and technological context in order to define a seizure how it should be defined.
Okay, you have 20 seconds left. You can wrap up.
More important. Yes, Your Honor.
Anything left, or you get...
Ultimately, the respondents are the only ones with a multitude of precedents specific to physical force seizures, while the petitioner rely on external cases that don't actually support the current case, such as Hodari, where there are non-binding dicta, and ultimately, similar to Brooks v. Genzel and other cases, this court should also rule that a seizure needs an acquisition of control.
Very good. And very impressive. We switched mass on up. That was actually a very impressive effort. So COVID points. All right. All right. Can the petitioners please begin? You have 5 minutes for rebuttal, please. And the response go off camera. Okay. May begin. Oh, you're both on mute. No, I'll restart your clock.
I apologize.
That's okay.
All right. Chief Justice, in addressal to the respondents' aims, we argue above all that Ms. Torres was principally seized in this case. The first claim that we would like to address in a quick rebuttal from our respondents is that Torres posed a direct threat to the officers via in the car, and they noted she was on methamphetamine influence. We would say no. By no means was the excessive force of actually shooting the respondent justified in this case. We would like to refrain that Torres got into her car upon seeing plainclothes officers who failed to identify themselves approaching and left. The second she hit the gas, they proceeded to open a fire of 13 bullets. It's 2 of which were shot erratically and actually struck the petitioner as opposed to the vehicle. Torres was simply getting into her car, or upon seeing 2 random men, they had no reason to shoot her, or to the excessive extent that they did.
All right, Counselor, so let me ask you a question. Your friends on the other side say that, these sort of common law cases are relevant. We should be looking to modern contemporary standards. How would you respond to that argument?
We would respond by saying that the Fourth Amendment is rooted in common law, and you can't really extract it from that. It was at the founding, the Fourth Amendment was created largely in response to writs of assistance and general warrants, which are warrants that allowed you to police officers to search based on pure suspicion. So it was created to protect against, violations and abuses of common law trespass and, the other elements, searches and seizures of common law arrest. Additionally, the argument that it is outdated, we would argue that it isn't, because it is rooted in this very still relevant principle of personal security, and the idea that the second that a police officer or even a stranger touches your body without authority or reason, that you have violated that the sanctity of the body and your right to privacy and security in your body. And that's what common law and the current precedent upheld by Hodari D really establishes and upholds. It's a very core principle, not at all outdated. Yeah.
Counsel, do you agree that your opposing counsel focused quite a lot on the language of Broward versus County of Inyo? And would you agree with me that Broward does have some language that really does seem to cut in favor of respondent's position?
I would agree. It does seem that way, but we would argue that when the Brower versus County of Inyo, the main focus and the main precedent it set forward was based on intent. The whole point of that case was to establish that seizures must be effected through means intentionally applied. So when you take phrases like there must be acquisition of physical control or restraint of freedom of movement, it's in relation to, intent. And in fact, the case which involved a driver crashing into a roadblock, the driver was killed on impact. And so, the termination of movement was really like irrelevant at that point. And additionally, the phrase that is most often used, which is seizures must restrain freedom of movement. We would argue that 2 bullets in the back, even though Ms. Torres continued to drive forward, her freedom of movement was restrained. In fact, her left arm was paralyzed by the bullets. She did not have the same freedom of movement that she had before the 2 bullets entered her body.
Let me ask you a policy question, Counselor. If we adopt your rule, won't it make it harder for police departments to do their jobs and keep us safe?
It may appear that way, but we think that if the respondent's policy was adopted, the threat on the citizens' right of personal security would be more endangered than police officers' right to affect their jobs without hesitation, or legal entanglement. And in fact, the precedent set forward by Hodari D and upheld by us petitioners is quite straightforward, and I think does not hinder police officers in that it's a very clear rule that they can easily follow in the field.
Okay, Counselor, that's time. All right. Excellent job, both teams. If the other team could please come back on camera so we can see you. That was fantastic. I got to tell you, you held your own. These are not easy cases. These are very hard cases. And I got to tell you, the sorts of questions we're throwing at you were above and beyond. And I need to give props to my old friend Rebecca, I've known for some time. You may not know her name, but she actually works for the U.S. Solicitor General. And she actually argued this case before the Supreme Court of the United States. I know, fangirl, right?
It was very cool. You guys did awesome. But I asked you and Josh and Sam asked you some of the same questions that the justices were asking. So really like real hard questions.
Yeah. So you guys are in for a treat. I've never argued for the court. I don't think Sam has.
No.
But Rebecca's. How many cases do you have now, Rebecca?
That's my only one because of the pandemic. But I have more coming up.
And you're batting 1,000. She won.
Yes.
She won the case. I don't agree with her opinion, but she won the case. I'm with the dissent, but what do I know? That's okay.
So
that's
wrong. So
I know. I'm usually wrong. But
I'm with Rebecca, but for what it's worth. I said I'm with Rebecca for what it's worth.
Okay, well then we got a divided panel. But truly, when I was in high school, I could never pull this off. What you did, this is simply remarkable. You're talking about precedents. You're giving us common law. You're distinguishing holding and dicta. You're trying to answer these really tough policy questions, which don't have good answers. What I really loved at both teams is you held your ground. And this is something that Rebecca can maybe speak to. When you take a position and the justice tries to throw you off the position, it's very important to try to stick to your guns. Because once you get thrown off your position, you're in the wilderness. You're sort of lost. And you really have to stick with it. Rebecca, I know you had this issue at your argument. Just maybe talk to students about like the importance of holding your ground, so to speak. It's a very good lesson to have.
Yeah. This can come up in a few ways. There are some really difficult, what we call hypos in this case, where it's like, what if you get tapped on the shoulder? Or what if the person is shot and just slows down but doesn't stop? And answering hard questions like that can sometimes make you want to back away from your position because you don't want to give an answer that sounds counterintuitive or unreasonable. And the trick is finding a way to remain consistent to your legal principles and in answering the hypothetical, but also sound reasonable. So like, Wynne, for example, you were getting the shoulder tap question, and that's tough. That's a tough one, right? Because you probably don't want to be saying, yep, every time that's a tap on the shoulder, that's a seizure under the Fourth Amendment, but you recognize that you had to stick ultimately with a line that's drawn at physical contact. And then you did a great job emphasizing the intent aspect as a limiting feature of your rule. And so that type of answer allows you to sort of stick with your position, but also sound reasonable, which is the balance you always want to go for.
Awesome. Sam, is there any feedback you'd like to give also? I'll make sure we'll get a chance to give some comments for the students.
Yeah, I agree with everything that's been said. The other thing to keep in mind, I've not argued before the Supreme Court. I've argued in front of courts. But one of the things that I did when I was in law school was a competition that's exactly like this, where you brief an argument to the Supreme Court, you go and you argue in a competition style in front of a Supreme Court. And having competed in many competitions, I will say you're better than some law students we went up against. So keep up the great work. I think what Rebecca was explaining about being strong in your argument is great. Gentlemen, you had a really good pace and a really good number of sound bites is what I'll call them, where you had things that you could go back to and that you could circle your argument back when we asked you questions. And Grace, I thought you did a great job in the rebuttal of not only recognizing that, I want to take a strong stance, but when Rebecca asked you about precedent and said, doesn't this cut against you? You admitted, you know what, yes, the case does say that, but that doesn't mean I lose. Because I think the last thing you want to do is tell a judge, no, you're reading this case wrong, unless they really are. That happens sometimes. But it's better to get in an argument about your case, your principles, than to be caught up on what is the holding of a case, or did you read the facts right? Or that's time that you don't want to get bogged down in. So that was handled very, very well.
Yeah, I think I asked one of you, was Justice Scalia correct? And I think Justice Kavanaugh gave the same question to Rebecca, which is funny because she clerked for both Judges Kavanaugh and Justice Scalia. It's like, so was Justice Scalia correct? I laughed out loud when I heard that argument. I was like, oh, that's pretty funny.
I tried to avoid it, and then he asked me again.
You knew that question was coming, didn't you? You probably.
I don't know. I have a couple more points if you guys are.
Yeah.
So I know Wynne praised you for your great, sticking with your guns on the hypo. I think just some other specific things. You all had really nice pacing. Siddhant and Pranav, you're both really articulate. Like you speak in clear sentences and paragraphs, which is a really impressive skill. I mean, I can barely do that now. And so I thought that was great. And you also managed to balance between the two of you, answers, and both demonstrated a lot of substantive expertise. Grace, you are a legal natural. You are drawing distinctions between cases and making substantive arguments that are really quite sophisticated. And I was really impressed by the substance of your remarks consistently. And then the last thing I would say for everyone is to echo a little bit a point that Sam made, which is about credibility, before the court. So Sam noted that Grace at one point, acknowledged the problematic language in Brouwer, but then went on to contextualize it, which is exactly the right way to do it. And I would say that level of candor with the court, is the most important thing to maintain an argument, because ultimately your credibility with the justices and the judges is the only currency you have at argument to get them to listen to you. And, I think in this case, I know this case very well, obviously, and so I'm very aware of the facts. And there are different ways to describe the facts in this case, and there's some, in part because there are remaining factual disputes. And so one thing that everyone, I think, should be really careful about is when you are describing the facts, just be really careful not to skew them too much for your side. A little bit of skewing is totally understandable because you want to present the facts in the light most favorable to your client, but you want to also acknowledge the bad facts, and because that will give you credibility with the court, and that just sets you off where they're like, oh, this person is speaking honestly to me, is going to highlight to me the problems and the strengths with their position. But amazing job, everyone.
Yeah, and also, Wynne, I think I want to make sure you get left out. I thought I gave you some pretty tough questions about common law rules. I think you sort of struggled and you fought, and I think you eventually got to the right place. I think all of you did truly spectacular. I want to make sure to give you a chance to ask us questions, because you have three lawyers here who have all gone through law school. We've all gone through the legal profession. We went to the bar. Are any of you considering law school? Any of the four of you? Thinking about it? If not, you should.
Yeah, me and Pranav are definitely thinking about going down that route. Yeah.
Well, that's great. How about you, Grace and Wynne? Any thoughts about law school?
Honestly, it was never on my radar until my history teacher recruited me for the club.
Should be.
I always thought of it as like a very scary, taxing profession. I wondered if you felt the same way or.
Oh no, I know, Rebecca, you're a real lawyer. I'm just a professor, and with Sam, you're a real lawyer. I just play one on TV. What do you think?
It doesn't have to be. I think it's what you make it, and it's you have to be honest with yourself about what it is you want to accomplish with the degree. Some of what you see on television, sure, you can find that sort of thing. What I like about it, I work with school law, so I work with school boards and boards of education and deal with everything that you deal with in school. I'm the lawyer on the other side. So it's cool because I get to do something that I didn't even know existed until after I graduated. But if you find something that you're interested in, you're passionate about, you get that history of it, or, I still get to argue constitutional law and the founding and some of these principles and how to interpret words. And there are fun aspects to it that I think don't get enough attention. All you really see is all the, crazy courtroom drama stuff.
Yeah, I mean, it's a great profession, I think. And it doesn't have to be, there have been periods of my career that are pretty taxing, like hours wise. And there have been periods that are less so. I have 3 young kids and my husband works full time too. So like it's doable. And like I see them and I get to argue in the Supreme Court. So you can turn it up and you can turn it down.
Yeah.
And there are enough lawyers in America that if you are interested in it, you can find your people substantively and personally and professionally. It's a diverse profession. So there's a lot of room for different paths within it.
That's awesome. Yeah, I'm a law professor, so I'm not really a lawyer. I just play one on TV. Mostly joking. But also, if any of you are interested in law school, I sent your coaches an email. I teach First Amendment this semester, Mondays and Wednesdays. I'll just give you the Eastern time, 2:30 Eastern. If you want to come to my class on Zoom, you're welcome to come by and stop and watch. I think you'll enjoy it. So it's a free invitation. Sure. Yeah. Oh my God. Yeah. OMG. Yeah. This Monday, Wednesday, or next Monday, it's at 2:30 Eastern on Zoom. You're welcome to come by.
Very cool.
I may cold call you though. We're doing I'm doing Heller in class tomorrow, which is another opinion Rebecca knows well. Are there any questions you guys want to ask us? Anything on your minds? Anything about law school, this competition, maybe the Torres case? You got the expert here. Not me. You got the expert here.
Not me.
Actually, I had one question. So
Please.
I know regarding law, I'm pretty sure like it can be a little bit like physically and emotionally taxing. And I'm pretty sure that like the costs associated with law school are also, quite large. So I just wondered if you could talk a little bit about that and like how to kind of go around that aspect of law school.
When you say cost, you mean money? I'm not sure. Let me sure you get the right kind of costs. Yes?
Sorry, Your Honor. I was just asking about the specific like costs associated with law school and like how to kind of maneuver around those.
But make sure you're talking about like financial cost.
Yeah.
Okay.
Yeah.
Well, the trick of law school is scholarships exist. If unfortunately they're often merit based, and they probably shouldn't be, but they are. So law schools will basically try to attract some of the best students to come to their institutions. And if you're able to have good grades and good LSAT scores, you can find a school that can give you substantial financial aid. What it usually comes down to is a balance, right? Maybe you get into a top 25 school that doesn't give you any money, but you go maybe 25 to 50 that does give you money, and you can sort of balance it out. But even the top law schools give a financial aid based on merit. Some also based on need as well. Unfortunately, student loans exist. I finished paying mine off about 2 years ago. They suck, but I think we all had them at some point. But it's worthwhile if you're thinking just in terms of dollars and cents, which I suspect you are. The JD, the law degree, adds a lot to your income over a lifetime. So it will, in almost all cases, pay for itself in the course of your careers. But when you're in college, which I hope all of you are going to college in the next couple of years, take some law classes. Take a class in constitutional law. Take a class in criminal justice, and you'll really get a feel for where you should be for your career.
And I know for me personally, I went back and forth all through undergrad. I wanted to be a history professor. I wanted to be an English teacher. I wanted to be a lawyer. I sort of vacillated. And I don't think that it was until my senior year in college that I thought, no, I'm ready. I'm going to law school for real. This is my plan. So take the time that you need, explore the avenues that you're interested in. And the finances are certainly a really practical part of it. So just be measured when you are looking at those things. It's exciting to go to a name school. It's exciting to go to the school of your dreams. Try to the best that you can, thinking about it in the long term. Don't assume that you will always be interested in the thing you're interested in the moment. Like if you're thinking you want to be this, big corporate lawyer, you might end up really loving something like legal aid instead. So just plan for not having a plan to some degree. And I think that helps open up a lot of possibilities for you.
Other questions you have? Happy to answer them.
Yeah, I had one last question. Sorry. So is it possible to like get accepted to a good law school if like you go to like a non-top 20 undergraduate school?
Of course. Oh, of course. Rebecca, how many people at your law school are from non-top 20 undergrads?
Gosh, so I went to Yale Law School. So did my husband, who went to University of Wisconsin at Madison. I can't think of like the exact numbers. My husband's best friend, who's visiting us right now, went to Calvin College, which is just like a small Calvinist college, and then went to Yale Law School with us. So I mean, a lot. It would be hard for me to think of numbers, but
It happens.
half, yeah. So it's totally doable. I mean, it's like, my husband, I'll just shoot straight with you, like he killed it in college, and then he killed it on the LSAT, and then he got into every law school he applied to, and I think he actually wouldn't have had it any other way, because he loved his experience at University of Wisconsin, and then he had a totally different experience in law school with different culture, and so I think it's actually a great path. Like, and for whatever it's worth, when I look at a resume like that, I actually like if I look at a resume like where someone went to like a state school and then like a great law school, I'm like, wow, this person like really like put in the work and shined, and like I'm probably more impressed by a resume like that than I would be by a resume like my own, which is like Yale. So I don't know, take that for what it's worth, but.
I went to law school. I went to law school at George Mason, which is a wonderful state school in Virginia. And actually Rebecca's dad was my favorite professor. So you can do whatever you want. I think you went to Cleveland Marshall, if I remember correctly, Sam?
I did. I went to 2 very small schools in Ohio. So it just depends.
You make of it what you will. The pedigree doesn't matter very much. I do mean that sincerely. I went to public school my entire life, through law school, and
Right.
Look how I turned out. All right,
Yeah.
we do have another round coming up in 9 minutes. I'll need to cut this short because I need to get ready for the next round. But we'll be in touch with your coaches by tomorrow. We'll give you the scores and we'll let you know what happens next. But thank you so much. This was wonderful. Both your teams were stellar.
Yeah.
Thank you so
Great
much.
job, everyone.
So if the judges can just stay on the call and the students can just sign off, and we'll go about the grading process. Thank you.
Sure.
Great job, guys.
Take care.
Thank you.
I'm going to turn the recording off.